All right, chapter 5, everybody. We are scooting through this. I think chapter 5 is going to have to be at least 2 videos, and then chapter 6 will be a video, and then the appendices will be a video. So, and then the book after that, I just wanted to show you this. I'm excited about it, and I hope it's what I want it to be. So, commentaries on the laws of England, book 1, and then I also have book 2, book 3, and book 4. So there's no end to what we can do as far as making chapter book summaries. And then just a few other ones that I got, maybe a little short video on natural law. And somebody bought too many books. Trial by Jury. So this is by Lysander Spooner. And then if there's time, probably by July, The Christian and American Law. So we'll see. There's plenty of resources. Oh, and I forgot this one. This is I got the Magna Carta just for fun. So I felt bad for that book. It only been checked out one time. So I don't know why that made me feel bad, but I'm like, no, more people should have read that book. So here we go, chapter 5. We are looking at common law and civil law, and they're being contrasted. So I'll just pause whenever needed. And I've got the actual text here, and I've got my notes. So, all right. Rival worldviews, common law versus civil law. There are 3 questions to ask that distinguished common law and civil law tradition. First, what is the source from which law springs? In other words, who has the power to create or make laws? Truly only the creator. And when man puts himself above God and tries to create law, then that is idolatry. So who interprets the law? That is, who decides which rules govern at any dispute? Well, it should be God's people, because no one except, the creator is above us. So it should be us, looking at these laws. And when something happens and there's a dispute, just like in common law, we decide which law applies and we work on it as a group of 12. So whom does the law bind? Everyone. So no one's above it, including, those that are serving the people in some sort of official position of government. Natural law, common sense versus baseless logic. Natural law stands for standards of conduct and relationships among men and women, discoverable by reason that rests on general revelation, which is knowledge of God's character and law through creation. So rests on general revelation or scripture and guided by an innate moral sense. It is an inborn capacity to sense right from wrong. Civil law says that all men know right from wrong. Paul the Apostle in Romans 2:14 through 15 asserts that all men can know right from wrong, not that they know right from wrong, and then cites 3 facts of evidence. Unregenerate men at times obey God's law. When unregenerate men disobey God's law, their conscience sting them. On the one hand, unregenerate men have accusatory thoughts about another person's violation of law, but on the other hand, when accused of legal violations themselves, they conjure up defenses and self-justification of their own violations of God's law. Civil law says that the scholastic is able to determine to free themselves from bias and produce good law. I say no. When you look at civil law and you look at how it's one size fits all, and they don't look at the individual cases, and they don't look at the people, and the state is the all-powerful, indomitable force pushing down on the people, that's not how it's supposed to be. It's supposed to be people self-governing. Next section, due process versus scholasticism. Scholasticism is reason taught in the scholastic tradition according to the rules of logic laid down by Aristotle. Roman civil law traditions says that when man fell into the sin in the Garden of Eden, his intellect and will were not impaired, and that unaided reason is able to free itself from bias and accept truth if the person wills it. Common law wants right relationships and the process that is due to each other in those relationships. That was one of the hardest things for me when I first started reading this is, the relationships is how we choose to interact with each other, how we choose to conduct our business with one another, when you're a neighbor with someone, when you're a friend, brother, and even living in one house, it's all of those relationships of interaction. So facts versus speculation. The common law appears illogical, yet has made a greater contribution to the cause of human liberty than all the rest because the common law concerns itself foremost with the relationships and the individual rights. Common law centers upon the courts which use facts. Justice Stone said, a court decision draws its inspiration and its strength from the very facts which frame the issues for decision. The common law looks to case law, statutory law, custom, and first principles. Civil law legislation is not reliant on the facts, but has a code or statute to follow, and the facts must fit into the statute and the code. Also, in common law, there has to be an injured party. Who's injured? And so with the state, you don't have to have an injured. They just set up a rule, for example, like speeding. And then if you are caught speeding, even though there's no harm done, even though no one is injured and you can't make anyone whole, they still want you to be punished because you just broke a rule. Although who's the injured party? There isn't one. So it's just control. That's all it is it's control. Legislative infallibility. Merriman, the name of a man, stated that retreat from the dogma of legislative infallibility has been a slow and grudging one. Yeah, so they try to look at the civil law and they try to think that it's all perfect, like Justinian code, and it's infallible, and there are no problems, but there absolutely are. Because you can't look at a case and you can't look at the individual facts of a case. You can't look at the reasoning and the why behind, people's actions. You can't look at them and their humanity and really comprehend. It's a one size fits all, and they just try to fit you in with some code you broke. So in common law countries, if the law is wrong, it can be changed. And that's absolutely wonderful. I mean, and it just makes sense. It seems insane that it would be any other way. Legislative finality. An essential difference between common law and civil law is not the presence or absence of legislative codes and statutes, but the finality that civilians, civil law attorneys, and judges attribute to legislation. Common law also embraces custom and court decisions, while civil law consists of legislation as an end. So when you look at civil law, its whole point is to control people in a tight situation like a city and have ultimate control over the people. That's all it wants is expediency, swift, and if it's right, it doesn't matter. It doesn't matter if it's right. It doesn't matter if it actually serves the people because the civil law serves the state, not the people. The people just live under that authority. And everyone's treated like a child. They aren't treated like men. Blackstone saw positive law akin to positive rights as a human institution of rights, not natural but created by man through legislation. I'll have to look into that. Say I needed to look into that whole Blackstone comment again. I just need to comprehend it. So 598, that's the page we're on. Blackstone understood positive law to be akin to positive rights. So this is not necessarily something in common law. A positive right is never inborn in a person, but is rather a human institution. So this sounds like civil law. And the right inherent in him is so natural, but a positive right. Thus, a positive right is the mere permission of the legislator given by man, not by God. Okay, so positive law, it's kind of a semantic deceit because you imagine positive law would be something that's good, like common law, but positive law isn't because it's civil. So the only one having the power to give also has the power to take. It's kind of like civil rights, they gave civil rights, but they can also take civil rights away. Whereas, our rights are inherent and they are God-given. They are not given by the state. Therefore, if man bestows rights by legislation, man can take those rights away by legislation. Positive law, then, is a decree contrived by the human mind and instituted often without consideration of the creator's authority. All right, so I'm glad we unpacked that. All right, now we're looking at adversarial versus inquisitorial. The common law tries cases. Mere accusations prove nothing. Conviction demands conclusive evidence offered by the process due by law. It is an adversarial tradition where each party, never the judge, determines his strategy for the contest, deciding how and who will be a witness and what questions will be asked. The roles of prosecutor, defender, and judge are separate and independent. Process is as weighty as substance. Accused enjoys the presumptions of innocence. The civil law holds inquisitions. The judge, not the attorneys, determine the scope of the court's investigation and decide what questions will be asked witnesses. The accused has no presumption of innocence, so the state's accusation equals guilt. Dystopian. So, real case and controversy. Common law courts only have jurisdiction over matters brought to their attention by a plaintiff's cry of genuine injury. So like I was talking about before, there has to actually be some injury, right? It was considered a bloody plaintiff, somebody that actually had true injury, not a person anticipating injury. So a real controversy, says Chief Justice Hughes, is not merely hypothetical, academic, but definitely concrete, real, and substantial. It is different from an opinion advising what the law would be upon a hypothetical state of facts. So digging a little bit deeper into, on page 608, it touches on hypothetical jurisdiction, and I'm trying to wrap my head around this, but the case that they're using, there's so much to read and it could go on forever, but I'll just read you the one part. The appellate court relied on common law first principle. Law forbids one to achieve that which is unlawful by otherwise lawful means. So even though the appellate court in a hypothetical jurisdiction case observed that the real dispute was over the most fundamental of issues, which was jurisdiction, definite, concrete, real, and substantial. The parties disagree as to whether we have jurisdiction to hear this appeal. So I don't know. I can't say that I'm 100% on this. So I think what I'm getting out of it is the common law's real case and controversy requirement reduces litigation by siphoning off those litigants hoping to use the courts for political activism and social engineering. It tends to bar from courts the less serious litigants, limiting use of the courts to seeking redress of genuine grievances. The main thing that's popping up in my head on this is, men that want to pretend that they're women and they want a right to go compete in women's sports when they were born with the hormones and the physiology and the skeletal and the muscular, makeup of a man. And then they think that it's somehow fair because something in their head tells them they're a woman that they get to now compete in women's sports with actually naturally born women that are valid women, real women, it's just that's kind of, there's no reason to go to court for that. A, you're not a woman, you're never going to be a woman. B, where's the injured party? Who's being harmed? If you want to go pretend that you're a woman, go do that, but don't insert yourself into women's sports and then muck everything up. So if you can't compete as a man, I guess you're not going to compete. So that's the closest thing I can relate to this. All right, for the next section, we are looking at how common law is process focused, very much focused on the process and the steps. And so when you look at this, not only does common law due process require ample and timely notice to opposing parties and a genuine opportunity to present one side of the case, it also provides more than a single opportunity in the right of appeal. Opportunities for appeal multiply, occasion to test all things against first principles, allowing parties and courts to uncover and recognize underhanded dealings, bias, ignorance, and misunderstanding, the weakness of humanity, ever present in every case. The procedure owing due process means ample opportunity. Used wisely, the process of the common law will uncover a multitude of truth that otherwise would remain suppressed. Practiced in its unadulterated forms, common law seeks to discover, not create. Okay, so I think that kind of explains. Though seldom able to meet separation of the steps, the common lawyer seeks the right application of the law by a six-step process. First, he masters the facts of the case at hand. Second, he discerns the relationships between the parties. Third, he compares the facts to previous cases, distinguishing for guidance those cases most on point. Fourth, he finds the applicable principle threading through the case opinions. Fifth, using that principle for the major premise and the facts of his case as the minor premise, he draws his conclusion. Sixth, he tests his conclusion against all other relevant precedents, facts, and circumstances. Common law repairs to precedent as the concrete empirical evidence of the law and its right application in view of the relationship of the parties before the court. Okay. So the next section brings up the Magna Carta, and we know that the Magna Carta was used to help formulate the Constitution. The written ideals of due process are a historical product that harks back to Magna Carta, Chapter 39, further back as unwritten custom. No free man, King John conceded, shall be taken or imprisoned or diseased or exiled or in any way destroyed, nor will we go upon him or send upon him except for the lawful judgment of his peers or by the law of the land. In the third reissue of Henry III, Magna Carta Chapter 39 became Chapter 29. So depending on which version you're reading, it changes, that section of the Magna Carta changes. And so this goes a little bit further into some history on the Magna Carta. So the framers of the United States Constitution in the Fifth Amendment due process clause received their understanding from Coke, which is actually spelled Coke, C-O-K-E. In his second Institutes, Coke proposed that the term by law of the land was equivalent to due process of law, which he in turn defined as by due process of the common law, that is, by the indictment or presentment of good and lawful men, or by writ original of the common law. And so the phrase due process of law first appeared in 1354. And to Coke, the significance of both due process and law of the land was procedural, but Coke's commentary on Magna Carta, Chapter 29, included rudimentary comments of substance restrictions. The phrase law of the land was clearly the preferred expression in English colonial charters and Declaration of Rights in North America, which gave way to the phrase due process of law, although some state constitutions continued to use both phrases. Regardless of which of the two phrases a state used, the concept remained the same and closely adhered to processes meant to safeguard life, liberty, and property of the defendant. And now we're going to look at cross-examination. Cross-examination is a creature of the common law, the child of the common law's adversarial personality grown to strength and, under skilled command, the fearsome foe of falsehood and fast friend of truth. So this is Wigmore, a quote from Wigmore. The greatest legal engine ever invented for the discovery of truth is cross-examination questioning. Cross-examination is the questioning of a witness at trial or hearing by a party opposed to the party who called the witness to testify, or by the party who has called a witness to testify that is hostile to him. I think in our culture, we watch enough shows or we spend our own time in court, we comprehend cross-examination. So powers separated versus combined. In common law, the separation of the powers of government are fundamental. Judges, legislators, and executives, governors, presidents, or other different government groups, they're all separated, so they shouldn't be meddling in each other's affairs. In civil law, separation of powers means legislators separate from the judge's discretion and reduce the judge's job to applying the code as written. The judge's role is narrow, mechanical, and uncreative as a functionary or civil servant. Judicial dissent. In common law countries, it is traditional that appellate courts' opinions include the majority opinion and dissenting minority opinions of the justices. In civil law countries, no judicial dissenting opinions are given. This is for the purposes of state solidarity, meaning no dissent allowed to the state laws. So we'll look at that a little further. So looking at the appellate court and the majority opinion versus the minority opinion, just to clarify, the common law tradition recognizes that informed minds engaged in disagreement multiplies the potential for truth to surface. For this reason, scrupulous observation of common law due process provides the appellate court minority on any issue with opportunity to declare and explain its viewpoint. In a common law country, minority appellate opinions are also a fundamental exercise of free speech. Common law countries welcome dissenting judicial opinions, acknowledging that the cases taken up on appeal are the harder and closer cases, of which men and women of common sense expect capable judges to disagree. By insisting that courts publish dissenting opinions, the common law tradition recognizes first, and the majority is fallible second. Even if the major conclusion is right, it can be right for the wrong reasons, because the reasons the court gives for its opinion become the rule of law used to measure future cases on like facts. It is necessary to challenge wrong reasons as it is to challenge wrong conclusions. Common law appellate courts are courts of record, publishing their dissenting minority opinions with the majority opinions. The majority opinions carry the binding authority of precedent upon all courts below them in their jurisdiction. So I can see why if somebody, the value of publishing both so that you can know their minds. All right, next section. So Glanville wrote the first systematic treatise on English law in 1187. It stated that a vassal owed his lord no more than a lord owed his vassal, and that if the lord broke faith, the vassal was released from his obligation to serve. All authority, the right to exercise power, comes from God, and any false claims of authority should be challenged. All men derive authority from God. To rebel against authority is to war against God. If revolution is rebellion, revolution is always wrong. There is no natural right to revolution. However, there is a natural right of resistance following lawful channels of procedure against unauthorized acts of state power. So on page 635, I just want to unpack that a little bit more of what we just read. So put another way, it is impossible for anyone to have authority illegitimately or to misuse authority because one cannot wrongfully hold or exercise that which is one's right. Thus, to exercise power without authority is not to misuse authority, it is rather to act outside authority's scope, to act without warrant. Since all men must derive authority held from God, it follows that to rebel against any authority is to war against God. Further, if revolution is rebellion, making war against God's instituted authority, then revolution is wrong. So the first time I read that in the notes, it didn't clarify that you were rebelling against God. There is no natural right of revolution. So against unauthorized acts of state power, however, there is a natural right of resistance that follows lawful, keeping with scripture, channels of procedure, such as exercise of the right of petition for redress of grievances, the right to access to a genuine court, and the right to judicial appeal. All these failing after genuine and patient attempts, resistance by force may be right, but only in extraordinary cases. The Parliament's war with the Royalists and the American colonists' war with England were such cases, and thus worthy of pondering. The foregoing distinctions between authority and power were indispensable convictions to the English Parliament and in their war with the Crown, and to the American colonists in their war with Parliament and the Crown. The English and American revolutions, so called, were not wars as rebellions against authority, against the authority of God, and therefore are distinguished from most other movements called revolutions, and particularly from those called revolutions in Western culture. So hopefully that clears that up. So now we're looking at dogma. The Greek political theorists use the term dogma to convey the characteristics of a total state, a positive ordinance from a distant and unquestionable authority, a command from which there is no appeal, and a doctrine by which the powers that be attempt to force all to give assent. A dogma, being from a distant source, is impersonal, being without appeal, discussion, and challenge, is to no purpose and thus disallowed. At bottom, a dogma is imperial, commanding, without reason, which is a command substituted for reason. Dogma signified Roman imperial edicts. Moreover, idolatry is one supplanting of God-given common senses to dogmas of men and false gods. So the next section on page 644, it's law versus legalism. And I hope I do a good job at explaining this, but they use Justice Scalia, and they use a story of a woman that had a permit, and so she could enter the country from China. And so in order to come over from China, you had to have a permit, and the immigration officers would check the permits. And so there was a statute that stated that if, you know, an immigrant was coming in, they had to have this permit, and if they didn't, they couldn't come in. So while she was on the boat on the way over from China, she gave birth and she had a baby. And so the immigration official basically said, you know, the baby doesn't have a permit, so we should send the baby back. And his his higher ups were like, don't be a damn fool, you know, that we're not going to do that. She's going to keep her baby. That's ridiculous. And so, but he was being, you know, as far as, you know, the legal, you know, rule that was on the books, as far as legalism, he was following, you know, the statute and what he was supposed to do to the T. And so that's something that the law allows. You usually don't see that in legalism. In legalism, you don't see it. So Justice Scalia really pushed that if anything was being done, you know, legally, the purpose behind Justice Scalia's policy of strict statutory interpretation is to force the legislation to be clear in drafting legislation, meaning those drafting up this, you know, legislative statutes, codes, you know, whatever it is that they're using, they need to be explicit. They need to be extremely clear on all levels. And Justice Scalia was one of them that did that, because law allows interpretation, but, you know, as far as their legal, you know, you can run into problems like the woman would have ran into when she was coming over from China. The common law's recognition of the fallibility of legislation, however, remains intact. Under the common law's separation of powers doctrine, the courts are to determine the lawfulness of challenged legislation by reviewing and testing it against the common law first principles. Known as judicial review, the courts have authority to weigh acts of the executive and legislative branches, and where found wanting, to find them unconstitutional or unlawful. So Justice Scalia spent a great deal of his time interpreting statutes and regulation. In 1943, 23 out of 37 reported cases in the courts of appeal were concerned with the meaning of legislation, people arguing about what things meant. And nowadays, the percentage is over 90%. And so this problem is not new, and it's a problem that definitely dominates. So I think this video is probably going to be long enough. I think we'll stop this one here, and maybe one more video and we'll be done with chapter 5.